Good afternoon, everybody. This May 19th, 2021 meeting of the Boulder County Board of Adjustment will now come to order. And before beginning, I'm going to go over a couple preliminary matters. First, it should be obvious to everybody, due to COVID-19 concerns, this meeting is being held virtually. Information on how to participate in the virtual meeting has been posted on the Board of Adjustment webpage at www.boco.backslash-BOA. There will be an opportunity to remotely provide public comment on the docket item today during the public hearing portion for that docket item. I'll provide instructions about that when we get to the public hearing portion of the agenda. Before we do anything else, I'd like to start with a roll call vote. My name is Eric Mounts, and I'm obviously here. I'll go through the other members that are present and take a roll call vote. And just a reminder to all of the members, when you are speaking, please state your name and announce yourself by name before you speak. Ms. Sarah Weavenson.
Present.
Mr. George Gerstle.
Present.
Mr. Scott Rudge.
Scott Rudge, present.
Mr. Robert Untitled.
Present.
Excellent, thank you. All votes are going to be roll call votes. You all have done this enough times that I'm not going to go through all of the other rules today. But generally speaking, try to speak slowly and clearly. And if you remember to check before you start speaking, please unmute yourself so we don't miss anything important you have to say. We have only one item today, which is a rehearing of docket number VAR 21-002, the Ray edition. Because this is a rehearing, I'm going to try to structure things a little differently and a little more efficiently than we would if this were the first time this docket item were here before us. I understand we're going to have a couple procedural issues to take care of, but as an initial matter, a rehearing is generally granted upon a vote of the Board of Adjustment. I understand that we have at least three members of the board who have indicated they are open to or consent to this rehearing. I also understand the county doesn't dispute that rehearing is appropriate, but I would like the county to confirm that on the record before we go any further.
Hi, this is Erica Rogers, Assistant County Attorney, and we as the county do not object to the board rehearing this matter.
Wonderful. Thank you, Ms. Rogers. The other procedural matter that I want to address is that obviously we've had a hearing previously, and I think it would make the most sense for us to incorporate the transcript of that prior hearing and the exhibits received in that hearing, the testimony received in that hearing into the record for this rehearing so that we don't need to restate the entire record. I'm going to ask that both staff, I'm going to ask both staff and the applicant if that is acceptable to both sides, that we incorporate the existing record into the record of this hearing. And I'd like both sides to let me know if they have any concerns or objections about that, or alternatively, if they consent to it here on the record before we go any further. Staff, is that procedure acceptable to the county?
Yeah, Ryan Ksarek, staff, Boulder County Community Planning and Permitting. It's, yes, acceptable to county.
Okay. Applicant, is that procedure acceptable to you?
Hey guys, sorry, it kicked us off for a second there. You started to talk about what was different and then we just jumped back on like 10 seconds ago.
Mr. Ray, I'm happy to restate it for you. Because this is a rehearing, it is a little different from a normal hearing on a variance because we already have a record and exhibits that were created in a previous hearing, right? So, and in fact, the rehearing is based upon, as I understand it, your perception of defects in that original hearing or a lack of opportunity to address certain issues. But in the interest of making sure that we have a complete record in avoiding, for example, staff having to go through their whole presentation again, I would like to start by both sides agreeing to incorporate the record from that previous hearing into our record today. And then both sides will be given an opportunity to speak. I'm going to vary again with permission from both sides, the usual procedures and effectively give both sides 10 minutes to speak on the issue of rehearing and the issues presented by the request for variance. But I want to make sure everybody's okay with that procedure because it does differ from what we would normally do. Typically, we'd have the staff give a presentation and the applicant would give a presentation. And I don't want either one of you to have to restate the things you've already said. And I'd rather you focus on the things that you think we got wrong last time and that are up for rehearing so we can really focus on and put our time to good use addressing those. So I'd like to make sure but I want to make sure you're okay with that procedure.
Yeah, that sounds fine. I might take a little more than 10 minutes. I've prepared a little bit of information. So as long as that's okay. I'm good with it.
How long are you planning on taking? We will have to have some reasonable limitation on time.
Oh yeah, it won't be any longer than my first presentation, 20 minutes.
Okay.
By 10, 15 minutes. I'll try to be brief.
Okay, well, let's say 15 minutes, and if there's some compelling reason to extend it, I'll consider it. Typically we don't give people 20 minutes to speak, and I can't imagine that you'll need it, but I also want you to feel like you've been heard and you've given us all the information that you need to give us. So we'll cross that bridge when we come to it, but try to focus on the new issues.
Excuse me, Scott Rudge, Board of Adjustment member. Can we recognize Kim Sanchez?
We can, yes. I see now I see her hand is up there in the corner. So yes, we can recognize Kim Sanchez.
Hi, thank you, Chair Mounts. Just to clarify, staff does plan on giving a brief presentation again today. We do plan on focusing on some of the clarifications, but in addition to incorporating the last documentation into the record, we do plan on giving a presentation today.
Sure, that's fine. And I'm not meaning to imply that either that the staff's not going to get their opportunity to speak. My plan was to give both sides the opportunity to speak, but I also didn't want staff to feel like they have to go back through things which have already come into the record. And same is true of the applicant. I mean, there's no reason to restate things that are already have been presented to us. So I understand Ms. Sanchez, and we'll absolutely going to give staff a chance to make their presentation as well. So after both sides have given their presentation, we'll move to public comment as we would in any normal meeting, because I understand we do have a couple members of the public who want to speak. And then again, like any other normal meeting, we'll give both sides an opportunity to respond to public comment if they choose to do so. And we'll then close the record and proceed to board discussion of the variance. With all that being said, and understanding this is an acceptable procedure for both sides' perspectives, I'll turn the floor over to staff who can make their opening statement.
Okay, Ryan Sarek, Boulder County Community Planning and Permitting. I will share presentation here and go through some of the stuff here pretty quick. It just for the step back here and for the record, this is variance VAR-21-0002. This is a variance for an addition in the setback. Just refresher through where we're at here with this. It's a rural residential zone property that's 0.86 acres. The request is to reduce the front yard setback from 25 feet to 20 feet. Quickly going through, I know we've seen most of these maps and locations of the parcel. The zoning is rural residential. I'll put the contours map up here again. This was something that we focused on in the last hearing, and I think can give a little clarity to this contour map shows this parcel's very flat parcel. Does not feature any significant slopes or elevation changes. There's nothing listed in the comprehensive plan here as well. In the last hearing, there was some confusion, I think, around floodplain and what the property has on it. Current floodplain mapping is what we see here, the 100-year floodplain and the floodway. This was the floodplain mapping that was included as the part of the referral packet. It was mentioned as being included in the staff recommendation, which we include with our staff recommendation are all the application materials that are referred out, standard map issued with referrals of all these type of projects. The applicant included with those same application materials included in the application packet, this letter of map amendment, the LOMA from FEMA, looking at the floodplain for the property subject parcel at 11170 Flatiron Drive. The outcome of this letter of map amendment, the LOMA, was removal of the property from the floodplain. So that's what we're looking at here, putting it out of the floodplain. Quickly looking through an aerial of the property just for us to look at this. I'll bump through the slides fairly quickly, and we won't need to go over the building permit history like before, but we are looking at proposed addition to the second story of this structure, with a portion of that being in the front yard setback up here at the top of the screen. So skipping over what was permitted before, the residence was permitted. The residence went through site plan review 20-0077, which approved a second story addition to the property, of which 16 square feet located over this portion of the garage is proposed in the setback. So the front yard setback is being proposed through this variance to be adjusted from 25 feet in the front yard to 20 in order to accommodate that existing area of the structure in order to build the second story addition onto the home. So again, this is looking at where that setback goes through the existing structure, where the existing structure is built into the setback, being this corner, and then the proposal for the second story being built on that same corner here with the setback line shown there. Some pictures, this corner and this corner here being the area located in the setback, and then again, this corner being that area that is within the 25 feet setback. We need to go over the referral responses. These haven't changed. The only thing that has changed and that I do want to call attention to here is also provided to the board and incorporated as part of the record, like we just talked about before I began my presentation. We did receive 5 comments from adjacent and neighbors within the neighborhood. All 5 comments received express support for the proposal, found that the proposal was, expressed support for the proposal, found the proposal was in character with the neighborhood, and felt that it was a something that would be well received in the neighborhood. So we'll hop to our variance criteria. I think this is important to go through here for the rehearing. Land Use Code Section 4-1202B2 A, the first criteria, there's exists exceptional or extraordinary physical circumstance the subject property, such as irregularity, narrowness, shallowness, or slope. Like we mentioned before and looked at in those maps, this property is 0.6 acres. It's approximately 124 feet wide east to west property lines, 300 feet long north to south property line. Property is flat, does not feature any physical circumstances that limit or influence the location of the development. Because of this, staff finds this criterion is not met. Going to the second criteria, because of the physical circumstances, the strict application of the code creates an exceptional or undue hardship upon the property owner. Staff finds there's developable area that exists on the property, especially to the south of the existing residence, this being the south over here. And because of this, staff finds this criterion is not met. Going to C, the hardship is not self-imposed. The proposed addition, staff found that the proposed addition involves the least amount of disturbance to the site, utilizes existing residents most efficiently. Staff found that in order to build the addition, as the applicant noted throughout their application materials, and as we discussed at length in the previous hearing, the applicant would have to remove a portion of the existing residence, redesign the foundation in order to support the addition that could be built. And because of this, the applicant is pursuing this variance to make it easier, to make the most efficient and least impactful method of addition to the property to allow for that to occur. Because of this, staff finds a hardship is not self-imposed, and staff finds this criterion can be met. Going to D, the variance, if granted, will not adversely affect the use of the adjacent property as permitted under this code. Staff finds a proposed addition as a second story addition will cause the least amount of disturbance to the site for an addition of the size, for the addition of that square footage. Staff found no conflicts with the use of the adjacent properties. If this addition were to be allowed to be built, because of this, staff finds this criterion is met. Looking at E, the variance, if granted, will not change the character of zoning district in which the property is located and is keeping with the intent of the code and the comprehensive plan. Staff finds this proposal not change the character of the rural residential zoning district. SPR 200077 found no conflicts with the proposed addition as it related to the site plan review criteria, which do largely look at neighborhood character, and the character of the zoning district is considered there as well. And then as listed here, Boulder County Comprehensive Plan residential goals, D3, residential goal, D.3, D1, 107, of the housing elements all support this proposal, particularly looking at the rehabilitation of existing residential facilities, and support this proposal through the sustainability element goals of the Boulder County Comprehensive Plan, looking at the policies within that to support structure sizes, additions, support rehabilitation of existing facilities. Because the staff finds the criterion is met, there's a car alarm going off outside my window, so I will get through the last criteria here. And then criteria F, the variance, if granted, does not adversely affect the health, safety, and welfare of the citizens of Boulder County and is in accordance with the comprehensive plan and any applicable intergovernmental agreement affecting land use or development. Staff finds no adverse effects to the health, safety, and welfare of the citizens through the proposal, and therefore staff finds this criterion is met. So with that, community planning and permitting staff recommends that the Board of Adjustment deny docket VAR-21-0002 Ray addition of setback because there's no exceptional physical circumstance that created a hardship, and the hardship is not exceptional or undue. Staff also is included in here recommending conditions if this is approved. Those conditions being that all relevant building code requirements must be incorporated into the building permit plans, and all other future development be subject to applicable permitting and setback requirements. With that, that concludes staff's presentation, and I will stop sharing my screen.
Thank you very much. Do we have any board questions for staff before you turn your video off? Okay. Ms. Weavenson?
Just one question is whether staff had received any additional information from the applicant in requesting the rehearing. Was there any additional evidence provided, or?
We did not receive any new application materials or anything like that, no. Only the public comment that was passed along.
Okay, great, thank you.
Any other questions from the board for staff? All right. Hearing no other questions for staff, we'll now turn the floor over to the applicant, Mr. Ray. The floor is yours.
All right, thank you. I said this last time, sometime my microphone goes, the volume on it drops a lot. So if that happens, please just raise your hand or cut me off and I'll stop and start up again. So let me share my screen real quick. Okay. So first of all, we wanted to start by thanking you all for taking time out of your days to come meet with us again on this topic. We're really sorry to hear that one of you had an emergency, and we truly hope everything is all right. So we started this variance process 6 months ago with the understanding that we had a strong case due to the fact that our house was fully permitted with 16 square feet in the front setback. We also understood that numerous soft denial applications had been approved by the BOA in the past. After the last meeting, we were obviously disappointed and kind of confused by the decision. Since then, we've done a lot of further research into the past rulings to try to understand how ours is different in nature from those that were approved. And we found there to be numerous examples of requests similar to ours that have been approved by the Board of Adjustment. We are here to discuss these cases and reiterate the impacts this variance will have on our community and then also us as Boulder County homeowners. So with that, I will go into my slides. Okay, items to review, review variance requests. I think Ryan did a good job at that. I don't think I need to go into that any further. I did just want to point out that the entire building footprint was fully permitted back in 1971, so 50 years ago. The main reason we asked for this rehearing, we feel like there's some inconsistencies with how our application and the criteria were considered relative to past Board of Adjustment rulings. We would like to review the impact this variance would have on our neighbors and the community and us as homeowners, and then review the hardship created by strict adherence to the code. I already reviewed the basic principles, or Ryan did. So the inconsistencies with how our application criteria were considered. At the last meeting, board members expressed different interpretations about variance criteria. It was stated that opposing board members in our last meeting that because we didn't meet criteria A, further evaluation of additional criteria was not possible or even necessary. This stance seems to clearly contradict past variance approvals. We believe this interpretation of the criteria is not consistent with past rulings. There have been numerous examples similar to our request that did not meet criteria A and were still approved. What I'd like to do is I'd like to review some of these variance requests, highlight the similarities to our situation for each, and then also highlight the staff recommendation and the Board of Adjustment notes for each. All right, so the first one was variance request 20. So this is year 2020, variance request 5. This variance request was to request a 4-foot side setback along the northern portion boundary of the setback, where a 7-foot setback was required to allow an existing detached garage on a 4.65 acre parcel. The previous owners of the subject property constructed a 60-foot by 40-foot detached garage in 1967 prior to the county having adopted building permit requirements for such structures. The applicant subsequently constructed a 30-foot by 40-foot addition on the east side of the original garage after purchasing the property in 1997. The addition was constructed without a building permit, even though one was required. Just to give you an idea of what you're looking at, here's that 4-acre lot here. This is the original garage. And then they went and they put an addition on, 20-foot by 30-foot addition that was in the setback. They did not permit this work. You can see here the lot is pretty much flat, so they could have put this addition or garage space anywhere on the property. Like I mentioned, no building permit was pulled. Staff and the board found the criteria A, B, and C were not met. Similarities to our request, the expansion of the structure did not increase the nonconformity in the setback from a distance standpoint. It didn't go any closer than 4 feet to the side property. Obviously, it went an additional 30 feet into the setback. But just like ours, we're not asking to go any further into the setback. We're just looking to build up above our current foundations. Alternate locations for the building existed per staff notes. The lot is relatively flat with no topographical constraints similar to ours. The Board of Adjustments approved this application. The next one requests a 17.6 foot side setback along the northern property boundary where there was required a 25-foot setback to construct an addition to an existing detached garage. So the basis of this is back in 1979, these people went through a variance request and were granted a variance request to build a garage within the setback. And then while staff agrees the strict application of the code created an undue hardship for the previous approved and constructed detached garage, since vehicular access and maneuverability for a car to be housed in the garage are difficult on the site, and the approved location addresses these challenges, staff does not find that the addition of a studio to the garage needs direct vehicular access, and it is possible for the studio space to be located elsewhere on the site without encroaching into the required setback. Therefore, staff recommends that this variance request be denied since one or more of the criteria cannot be satisfied as required, and alternate locations exist for the studio. That is give me a second. I don't know if there was a map around the beginning here. There's not. So basically, what happened on this one is that they were trying to build on top of their existing detached garage, right? Similar to what we're trying to do. And they needed a variance to have that work permitted, obviously. So criteria B and C were not met. Similar to our request, this is an expansion of a second-story addition to an existing structure within the setback. We believe that the existing variance granted for the original structure is very comparable to our home being fully permitted in Boulder County in 1971. The Board of Adjustments noted that a variance would not cause substantial detriment to public good or substantial impairment to the intent and purposes of Boulder County zoning resolution effective at this time. And this is very consistent with our situation as well. Again, alternate locations for this building existed per staff notes, and this was approved by the Board of Adjustments. 62 Barber Lane was a lot that was originally deemed unbuildable. A residential structure was mistakenly built and received final inspections in 2011. Because of this, Boulder County agreed to recognize this parcel as a buildable lot based on the principle of estoppel. This lot, the home expansion expanded the home further into the setback. And then staff recommended approval of this variance based on the principle of estoppel. Similarities to our request, residential structure mistakenly permitted when it did not conform to code. Variance approved because of past errors from Boulder County. The lot is relatively flat with no topographical constraints similar to ours, and this was approved by the Board of Adjustment. 15 Leon Lane, variance was requested from a setback requirement for construction of a new residence on the foundation of an original residence. The original residence received a building permit in 1983 for construction 20 foot near the rear property line. In the 1990s, Boulder County clarified the lot line setbacks in this area to conform to a 25-foot setback requirement. In this application, criteria A, B, and C were not met. Similarities to our project, alternate locations for the building existed per staff notes. The lot was relatively flat. Seeking variance to build on top of a fully permitted existing footprint. And there was, like I said, no topographical constraints similar to ours. This was approved by the Board of Adjustments. I believe this is the last one. On 75th Street, existing residence is partially in the setback because of setback changes after the home was built. Variance requested to build a new deck in the setback. Similarities to our request. This one is a little different because in the staff recommendations, the staff stated that the existence of a fully permitted residence partially in the setback created an exceptional physical circumstance and an irregularity in the property, criteria A. So staff actually recommended that because this was fully permitted and built, that it was basically a criteria of the lot. And this was our exact argument as to why we believe we met criteria A. Yet obviously that was not agreed upon with the group. Further, the staff recommended a condition of approval stating that any new construction shall not extend any further west than the western elevation of the existing residence so as not to increase the degree of nonconformity of the structure. And this is exactly what we are proposing to do at our house. And actually on this request, the applicant wanted to build a staircase that actually did extend to their deck further past the house. And they revised their plans to build it off to the side. So they were not encroaching into the setback any further. Again, this lot was relatively flat and with topographical constraints similar to ours, and this was approved by the Board of Adjustment. So given these past variance approvals, I'm trying to understand why our application is different than these other ones. And I just wanted to point out, in the past 4 years, there's been 31 variance requests submitted. Only 3 have been denied, all asking for kind of extreme circumstances here. Major, you know, a solar panel array 5 foot from Arapahoe Road. Major changes to setbacks to 1 foot and 5 foot on a 4-acre lot, and then 4 new structures encroaching 40 feet into a 60-foot setback. In comparison to these, our garage encroaches 4.5 feet into the setback, resulting in 16 square feet of non-conforming space, all of which was fully permitted. Impacts of our variance request. There would be no negative impacts to anyone or anything should this be granted. We will not have any impact on the health, safety, welfare of the citizens of Boulder County. We will not block views from any of our neighbors. We will not adversely affect the use of adjacent properties. We will not change the character of the zoning district. We will not change the character of the neighborhood. Our neighbors support this project and this variance request, and there has been no public opposition at any step in our process. And Ryan mentioned the reference letters sent by some of our neighbors. You know, as I was thinking about this, the setbacks exist to ensure the safety and create conformity in a neighborhood or zoning district. And what we're asking to do is not increase the degree of non-conformity in our project. And like I said in the last slide, there's really no negative impact on anyone should this variance be granted. And then the variance, you know, exists to relieve Boulder County property owners from undue hardships. And we truly believe that strict adherence to the code in this case creates a hardship for us in numerous ways. One, from a time aspect, financial and architectural appeal. From a time aspect, you know, we've spent so far 6 months in the variance approval process, getting in the queue and then meeting with you all. And again, we entered into this because we had an understanding that we had a strong case because of our fully permitted house and foundation. We also understood that there was numerous soft denial applications that were approved. Our optimal construction window is June through September due to the nature of our project. We're ripping off almost the entire roof of our house so that we can build up, and we can't do that in the rainy months or the winter. If we are not approved, we will have to redesign architecturally and structurally. We will have to resubmit for a permit and then redesign our roof truss drawings. All this will take months, and it would make it highly unlikely we would start our project this summer, basically making us wait another year until 2022 to get this started. Financial impacts, variance process fees. We're paying hourly for the planner services and expect the variance process will cost us around $1,000 to go through this. We'll have to redesign our architectural floor plans, elevations. We'll have to redesign our structure, and then we might also have to pay to redo our truss shop drawings, which are completed. This will also add construction costs for the new structural solution. And then the last item, the architectural appeal, the new design solution to avoid the setback would cause a funky notch in our house. It's extremely visible from the road, as this is like the very furthest point of our house to the road. So this is obviously the closest part, so it's the most visible. In summary, if approved, our variance would have no negative impacts. If denied, it would create numerous hardships for us as the property owners. Conclusion, we are bound by budget, seasonal time constraints, given the nature of this pop top, both of which would be greatly impacted if we were required to start over with our planning and reapply for our permit. Our neighbors have written letters and shown up today in support of our proposed project. There's been no public opposition at any step. Our plan does not adversely impact anyone, nor does it further encroach into the setback or pose any safety concerns. As Ryan hit on, our plan is the most cost-effective, structurally sound, energy efficient, sustainable approach to adding square footage, and it was approved by the SPR process. Further, all of our objectives are congruent with the Boulder County Comprehensive Plan, as Ryan also hit on. As you've seen, there are several recent examples of variance applications consistent with ours that were approved by the Board of Adjustments. Some of with relatively flat lots, no cliffs, or large rocks, topographical constraints. Many of these examples were given soft denials from the staff and did not meet criteria A, B, or C, but were still approved. 2 were granted based on the premise that their structure was permitted by Boulder County years ago, which is our exact scenario. So basically, we're asking the board to reconsider the stance, given the additional information that we've provided today, and we hope that we've made it clear that we think this impact of what we're asking for is really minor, extremely minor in the grand scheme of things. And we really hope that you'll reconsider our situation. So I appreciate your time. Thank you.
All right, thank you, Mr. Ray. Do any of the board members have a question for the applicant?
I have a question that may be appropriate later, but if we need a clarification from the attorney, is that based on something that the applicant has said? Is that appropriate now or later after public comment?
Why don't we save that for board discussion?
Okay.
If necessary. Hearing no other questions, first of all, any other questions for the applicant? Okay, hearing no other questions for the applicant, we'll now open the public comment section of the hearing. And so we will give the opportunity. I understand we have a couple of folks signed up to provide public comment. And unfortunately, I'm trying to find the sign-up sheet and I don't see it. So perhaps someone from staff could help me identify.
Chairman Mouts, I can identify them for you. The first, this is Scott Rudge, Board of Adjustment. The first public comment is from Jenna Gilbert.
Ms. Gilbert, you here?
Hi, yeah, I'm here. If you'll forgive me, I'm a nurse, so I have done few Zoom meetings over the last year. So I'm a little nervous. just forgive my anxiety. But anyway, my name's Jenna and I live at 3920 North 109th Street with my husband, Mike. And we fully support the variance request as it was initially presented, that the Rays are requesting. As they very concisely presented to you, there would be no negative impact in our neighborhood. There would definitely be a negative impact to them if they had to rework their design. There are many good examples, as Keen presented, of other variance requests similar that had been approved. And I don't think, I haven't spoken to everyone in the neighborhood, but I don't think that it would be opposed by anybody, seeing as their garage already is in the setback. Is there anything else that you would like me to say?
No, public comment portion is just intended to let folks comment on the proposed variance, and you've done that. So I don't think, unlike with the applicant, we'll be asking you any questions. So I think, Ms. Gilbert, we appreciate your time. Thank you.
All right, thank you.
Mr. Rudge, who's our second?
Second one, Scott Rudge, Board of Adjustment, Kathleen Rodriguez of 11152 Flatiron Drive.
Ms. Rodriguez, are you here? Ms. Rodriguez.
This is Anna Milner, staff. I believe that Ms. Rodriguez might be a panelist under Mr. Ray's name. Is that correct? It looks like we've got 2 Keen Rays here, and I believe that she may have signed up in the chat under Mr. Ray's name. So you should be able to press unmute, Ms. Rodriguez.
Or is it the
Hello?
attendee listed as CPP test?
There
I'm
we
sorry.
go. I think I
think we-
Ms. Rodriguez.
Hello, there she is.
Hello?
Yes, ma'am.
Hi, my name is Kathleen Rodriguez. I am the neighbor to the immediate west of the Ray residence. We're at 11152 Flatiron Drive. This house was originally built by my father-in-law. It was one of the first houses in the neighborhood in 1971. He is still the owner of this house. Unfortunately, he has dementia. I am his power of attorney, and we have lived here in this house with him for 9 years. And it is our intention that this home will be in our family for the long time in the future. Anyway, we have absolutely no problem with the raised variance request. You know, we have immediate, you know, their house is in our view to the east, and we don't feel that that would impact us or the neighborhood in any negative way at all. And we fully support their efforts.
Thank you, Ms. Rodriguez. I appreciate your perspective and comments. It doesn't look like we have any other members of the public who have signed up to speak. Are there any other members of the public present who would like to speak?
I don't see any others. It's Scott Rhodes, Board of Adjustment.
I don't either. So with that being the case, we'll now ask both staff and the applicant whether they have any additional comments based on the public comment we've received. And then we'll close the public portion of it, or we'll close the record and the hearing, and the board will deliberate. Staff, do you have any comments in response to the public testimony?
Yeah, only one thing for staff to give clarification to. Just with the way that this the process has worked, staff approved SPR 20-0077 with the condition that the addition be approved except for that part in the setback, and that the applicant either at the time of building permit turn in plans showing no addition to the setback or go through a variance. So that's the impetus for us coming to this, but I wanted to put that clearly there, that it went from SPR 20-0077, which approved an addition except for the portion of the setback, and gave the option to either turn in a updated building at the time of building permit, updated building plans with no addition, with the no portion of the addition of the setback, or go through a variance. So that's what we're here for today. That's it.
Mr. and Mrs. Ray, do you have any further comments?
No, I don't think so. Thanks.
Okay, thank you. We'll now close the public portion of the hearing and start board discussion. Just to kind of kick things off, fundamentally, there are a couple things that strike me here. The first is that as to the merits of this application, my opinion hasn't changed from the last time we were here. I was in favor of granting this variance last time. I am still in favor of granting it. As the applicant has pointed out, we have granted variances under similar circumstances. I don't see a basis for denying this variance, and it just doesn't seem to me to be reasonable to do so. My only hesitation and reluctance is that this is a rehearing rather than original proceeding, and I am concerned that there wasn't a valid basis for rehearing, other than the fact that the applicant didn't like the decision, and a couple of the members of the Board of Adjustment were inclined to vote for rehearing because of that. And as a body, I am concerned that we ought not be in the position of granting requests for rehearing and reversing ourselves every time somebody doesn't like a decision that we make. And so my reluctance and my concern about voting today in favor of the applicant is because of that, my concern for having some finality in our decisions. But I think particularly given the nature of the other variances approved, and what the applicant's asking, that even with that concern, I am still inclined to vote in favor of the applicant and the variance today for the same reasons that I articulated last time we met on this variance. And I would be interested in seeing if any of my fellow board members have decided to change their mind, or what your pleasure is with respect to this variance today. Who'd like to go first? Ms. Weavenson?
I think Scott had his hand up first, if you'd like to start with him.
That's fine. Scott?
I don't need to go first. I'll cede my comments to Ms. Weavenson.
Okay, Sarah Weavenson, Board of Adjustment. I think I just wanted to ask for some clarifications as a starting point from the attorney. The applicant in their presentation made several points. So I have 3 questions. The first is just in general, whether precedent is something that the board should be considering looking at past decisions. Second, in one of those past decisions that they cited, variance 17-005, I think they mentioned another one as well. They said that the board had decided that a physical structure, a residence that was already constructed in the setback could constitute a physical exception that could meet criterion A. So I was just curious whether that was not my understanding of what criterion A would cover, that it was more of a unique physical circumstance of the lot itself. And then the third is just that I know I'm a fairly recent member of the board, but in my training at least, criterion A has to be met before you move on to considering criterion B. And it sounds like there is some confusion about whether that is our standard that we should be looking at. So if that could just be clarified by the attorney, I would appreciate it. Thank you.
Ms. Weavenson, so the first question was the extent to which precedent controls the decision of the board. The board really has complete discretion to determine what constitutes a proper precedent for its action in a given hearing. And there is no rule stated in our rules or in the statutes that state that the Board of Adjustment is bound by precedent. So it really is committed to the proper discretion of the board as to whether or not, to what extent that precedent that's cited to you is going to be controlling. With respect to physical circumstances, once again, there's nothing in our rules and nothing in the land use code, nothing in the statutes that states specifically that physical circumstances relate only to the topographic conditions of the natural topographic conditions of the property. But case law throughout the country has generally indicated that that's the way that should be interpreted. So generally speaking, it is limited to the natural physical circumstances. And finally, the land use code requires that an application for variance to be granted, all 6 criteria must be met. And therefore, if you take them sequentially, of course, and criterion A is not met, then it really makes, there's nothing left to be argued because you haven't met one of the criteria, and you have to meet all 6 criteria. Whether or not this application meets all 6 criteria is completely in the discretion of the board.
Thank you for that. I have no further questions.
Mr. Rudge, you want to go next, since you were courteous enough to cede your time to Ms. Weavenson there?
Scott Rudge, Board of Adjustment. Chairman Mouts, I actually saw George raising his hand, so I'm happy to cede to him.
Go ahead, Scott.
Okay, Scott Rudge, Board of Adjustment. I may be the only board member who was on the board for all the cases that were cited by the applicant. Eric, you may, I don't know if you missed maybe the 2017 one or not, but I can say that the thinking of the board throughout the past 4 to 5 years has been that the part of the board's role is to make adjustments when the strict application of the code simply doesn't make sense relative to the objectives of the county in terms of its land use and so forth. We have made rulings based on the environmental impact of having to do something else rather than just build on an existing structure. And we have had concerns that that's not necessarily a permitted exception to criteria A. And in general, it's criteria A that where we have differences of opinion, I'll say, on the hardship rule and the necessity of physical alternatives. We have written a letter to the Boulder County Commissioners asking to extend our authority under provision A to consider environmental impacts of disturbing additional land and so forth, and making requiring applicants to do things that are more costly to them, more costly to the neighborhood, more costly to the physical environment. And I asked this question during the last hearing, and our attorney Larry Holt had confirmed that the county commissioners had not yet responded to that letter, although they had planned to. I believe if we had that clarification from the county commissioners, this would be an easy case for us to decide in the affirmative. I'd also like to say that simply because the applicant has a letter of map amendment doesn't mean that the rest of that property is not going to be underwater if we had a serious flood, and a requirement to make them build or to make them make some kind of unsightly alteration to their second floor simply for the sake of this purity doesn't serve any of the county's interests. So I'm not in favor of asking them to build in other level flat areas of their lot, even if it's available to them. And then I'd like to also address Chairman Moutz's concern, because I do have the same concern and have had the same concern since the first day of my tenure on the Board of Adjustments, that whether or not precedence guides us or rules over us, it's in our best interest to be consistent and provide certainty to the applicants, because ideally we wouldn't exist. There would be certainty in the rules themselves. And as many of the staff would be happy to tell you, I've long been in favor of having amended setbacks, for example, in El Dorado Springs, because every single thing that happens in El Dorado Springs has to come in front of us because the setbacks are so crazy and when they're applied in El Dorado Springs. And I'm going to say that the same thing applies here. The setback into which this applicant encroaches 16 square feet is really not an appropriate setback. Would it be nice if there was one single rule that we could apply uniformly? Absolutely. Then it wouldn't be taking any more of our time. I am concerned that, everyone now will think that they're entitled to a rehearing if they don't get the answer that they like. But on the other hand, I think that we weren't consistent with prior rulings, of which 3 out of the 5 board members were not participants in. So if the Board of Adjustments is now going to embark on a different route in interpretation of its role and the interpretation of the 6 criteria, I mean, that's fine. We can all go on that journey together. But we're going to have a lot of unhappy people who expected some certainty based on our previous actions, and they're not going to get it. And then I'm sorry, I think I said that was my last thing, but I just want one more thing. The applicant today has referred several times to a soft denial. And I do remember Mr. Kasirik saying in the previous hearing that this was what he termed a soft denial. Staff feels that they need to, staff legally has to adhere strictly to the 6 criteria. Whether they do so consistently or not is their problem, not ours. Because I do believe that there's times when they don't even, they amongst themselves don't apply those 6 criteria exactly uniformly like a robot. They're all humans as well. But they did say it was a soft denial a couple of weeks ago. The applicant has referred to that several times. I do believe that this is a soft denial on part of staff. I don't believe that staff thinks that approving this variance would be detrimental to the comprehensive plan or to the county or anything like that. And so similar to Chairman Mouts, my sense is not changed from our previous ruling. I plan to vote in favor of the applicant. I'll cede my time.
So, Chair Mouse, should I speak now? Your mute is on.
I'm sorry, Mr. Gerstle. Yes, I recognize you. You may speak. Please do.
Thank you. George Gerstle. I agree largely with Mr. Rudge's comments, and I summarized for myself as I was listening last time and then listening again to the presentations. I think what is the purpose of a setback? And it's largely for view protection, traffic or safety or emergency access protection or utilities. And in this case, because there's already the structure within the setback, this does not make it a worse violation of the setback. And in fact, if we were to reject this request, it would be contrary to almost every other relevant policy that the county has, whether it's the building, environmental, almost every other county policy that was listed in the presentation. So I really see no public benefit to rejecting the variance request. Indeed, I think it's not approving the request would be contrary to us accomplishing most of the county policies that relate. And then finally, the point about whether this is an extreme, something too extreme. I think we need to look beyond the geologic and look at the flood impacts, and that though I recognize FEMA has provided their blessing, one thing we've learned is that we're going to be seeing much worse flooding than ever before, and that we should be, if possible, reduce the impacts of flooding when making decisions. And so I think that adds to the need to approve the requested variance. So I intend to maintain my perspective that we should provide a variance if we were to make progress to many of our county policies that apply. Thank you.
Do any of the other board members want to speak? Mr. Ukile, do you have anything to say?
Yeah, thank you. This is Robert Ukile. My thoughts have not changed since the last time. I still feel like the application does not meet the criteria A or B for the reasons stated by staff and council, and also for the applicant's original letter where they discuss what they think is the most significant impacts. I wanted to say that I appreciate the community members submitting written comments and also attending the hearing. But it seems to me that those comments only go to criteria is D, E, E, and maybe F, that they're not relevant to the criteria, which are the basis for denial, which is A and B. In terms of precedent, I believe that the members of the board have an obligation to enforce the code as it's written. It's often referred to as the plain language. And the plain language of the code in between sections E and F, it says and. And so that's a clear indication that all 6 criteria need to be met. And I don't think that all 6 criteria have been met. To the extent that there were prior decisions that conflicted with the plain language of the code, I can't use that as a basis to depart from the plain language of the code. As some of the members have mentioned, the commission could certainly change, the county commission could certainly change the plain language of the code. And if they did, then I would do my best to follow the changed plain language. But I believe our obligation is to follow the plain language as it's written. And then a final consideration is I am still far from convinced that the original structure was permitted to go into the setback. Staff didn't mention it this time, but last time they did present us with a document which was part of the application, which said that the structure would be further back than the setback. And so that raises serious concerns for me that the structure was not permitted to go into the setback. Now, there's a separate issue of whether the county failed to enforce that violation or deviation from the original application. But to the extent that the concept, something like estoppel would apply, it certainly does not apply to a situation where the county, for whatever reason, decided not to enforce. And it could be that the reason is they weren't aware of it. But in any event, a failure to enforce it is not a grounds for the second deviation of the setback requirements. And then my final thought is some of the other members seem to frame this as a choice between building as it's currently proposed and or taking up more space in the property. But I have not seen any indication that those are the only 2 options. Rather, the applicant themselves have acknowledged that one option is to, quote unquote, do a notch in the expansion to keep it out of the setback. And I'm in no way saying that that's what the applicant should or has to do. I'm just pointing out that there are, if we don't grant the variance, there are several options for how the applicant can proceed. Thanks.
Thank you, Mr. Utilely. Do we have any other board discussion?
I'd just like to add a couple more. I've kind of only asked questions before, so if I could just make my comments. I appreciated all the thoughts that my fellow board members have made. This is Sarah Weavenson, Board of Adjustment member. Having worked in city government for many, many years, I can attest to the fact that variations are typically considered, they're meant to be the exception to the rule, not the rule. And the reason why they're not done at a staff level is because they're very hard decisions. And if we just said yes to them all the time, I don't think we'd be doing the work of the elected officials who appointed us in making those decisions that staff level decisions cannot make. So it's unfortunate, you know, as has been pointed out tonight, it's really, we're given the code in its current form, and that's updated, and over time decisions will be made based on other codes. But we are not a policy-making body, and we should not be varying from the code ourselves. We have our criteria that we've been given to make those decisions, in my opinion. So I unfortunately am also, I haven't seen any additional information tonight that would change my opinion from the previous discussion.
And it sounds like that everybody's had a chance to speak, and I appreciate all of your thoughtful comments and attention to this matter. Does anybody want to make a motion?
Scott Rudge, Board of Adjustment. Chairman Mouts, George Gerstle has his hand raised, and Ryan Kacirik, the staff planner, also does. One of the reasons that we're having a rehearing is because we allowed staff to make further comments. And I've seen in the chat that the applicant would also like to make a further comment. So I'd like to submit a motion. My motion is first to hear Mr. Gerstle, and then to allow 2 minutes each for the staff and the applicant to make further statements.
I would just,
That was a motion.
I'm sorry, George Gerstle with.
No, that was well, Chairman Mouts, do you think we need to vote on that motion?
Well, so
of course, George can say what he wants to, but the other.
Yeah, so let's deal with this as two separate issues. First, Mr. Gerstle, do you have anything else you want to add? It wasn't clear to me that you would put your hand up again. It looked like it might have just stayed up from.
No, I've had my say. I just think this is we should look at the totality of the requests and the impact on the individual in making a decision. And this would not make any impact on the public. Worse, it would make the accomplishment of other policies the county has adopted more difficult. And I recognize the strict reading of the regulations would say we shouldn't approve it, but common sense tells me that we should approve the request. So everybody has their own interpretation. So thank you.
Thank you.
I would also like to say I would prefer not to let staff comment at this point. One of the reasons we're having a rehearing is because staff commented after the close, and then the applicant complained about that. So I would like to not let staff comment. I'm fine to let the applicant talk. I realize that also is not in compliance with the rules, but obviously the applicant can't complain about us letting the applicant speak more.
So Mr. Utilely, I appreciate that sentiment, and I think I am inclined not to let either staff or the applicant make any additional comments, precisely because this is the problem we had last time. We allowed staff to make a comment, and then although with the consent of staff and the applicant, we then let the applicant respond and make additional statements. We have a procedure here which I've applied to today to this proceeding, and which we ought to follow. And that procedure calls for staff and applicant to make their statements and us to ask questions, and then for us to close the testimonial part of the hearing and proceed to board discussion, which is what we've done. I do not see any good reason to reopen the testimonial part of the hearing and hear from staff and the applicant again. Everyone's had their say. At some point, the opportunity to submit information to the record has to end. We do, however, have a motion from Mr. Rudge on the floor to reopen the evidentiary portion of the hearing, and we certainly can consider that motion. And if the majority of the board votes in favor of it, we can reopen the evidentiary portion of the hearing. And so I suppose the next question here is whether any other board members have anything they'd like to say on this subject, and if not, does anyone want to second Mr. Rudge's motion?
I would offer a friendly amendment that the motion just allow the applicant to provide additional statements and not staff.
Okay, so we'll do that.
Scott Rudge, Board of Adjustments. I'd like a vote on my motion if there's a second.
Oh, I think the proper procedure is first to have a vote on the amendment if there's a second for it, and then you vote on the motion as amended if you decide to amend it. So do we have a second for Mr. Ukili's motion? All right. Going once, going twice. There is no second for Mr. Ukili's motion. And so that motion will be deemed denied. Do we have a second for Mr. Rudge's motion to reopen the evidentiary hearing to allow the staff and applicant to make a 2-minute statement? Hearing no second on Mr. Rudge's motion, that motion will also be denied. Does anyone want to make a motion on the merits of VAR 21-0002?
Scott Rudge, Board of Adjustment. I'd like to make a motion that we grant the variance to VAR 21-002 with conditions as stated in the staff recommendation.
I will second that motion, Mr. Rudge. All in favor of Mr. Rudge's motion, and we'll take a roll call vote. Sarah Weavenson.
Nay.
George Gerstle.
Support.
Scott Rudge.
In favor. Scott Rudge, Board of Adjustment.
Robert Ukili.
Robert Ukili opposed.
Eric Meltz in favor. And again, we have a majority in favor of the motion to approve the variance, but a super majority of 4 of 5 is required in order to approve the variance, and therefore the applicant's request for variance 21-0002 has not been approved and fails. That concludes, I believe, unless the county or council has something they'd like to add or address today from a logistical or planning perspective, I believe that concludes our hearing today. And Mr. Hoyt, do you have something else you would like to address?
Yes, but just for the information of the Board of Adjustment members, just to update you, the Board of Adjustment did not decide to seek certiorari from the Colorado Supreme Court in the Save Our St. Vrain Valley Inc. Case. However, Martin Marietta, as the successor in interest there, has sought certiorari, and so I just want to let you know that case may still go forward.
Can I ask a question about that?
Sure.
Sure.
So you had stated, though, that if we don't seek cert, that means that we can't participate in the case if cert's granted. But I don't understand why that would necessarily follow.
A party to the proceeding has to seek cert or join in the petition for cert in order to proceed with the certiorari proceeding.
Well,
But
party, sorry.
I was gonna say, I think, and I did probably anticipate your question, but if cert is granted in the case, presumably Martin Marietta is not going to be the only party that's allowed to submit a brief. The appellee at the Supreme Court level will be allowed to submit a brief, and presumably the Board of Adjustment in Boulder County are still parties to the case and would also be entitled to submit some briefing to the Supreme Court. Am I gotten that correct, incorrect, Mr. Hoyt?
Yes, assuming cert is granted on the petition of Martin Marietta.
Okay, so assuming cert is granted, that the board and county could participate in the briefing. And so I think that one question the board may have to consider is, if cert is granted and the board has an opportunity to participate in briefing, what position do we want to take with respect to briefing on this case? And it may be that because the composition of the board has changed and is generally, I think, more supportive of the position of CMRC in Green Valley, that the board may wish to either not offer any support to Martin Marietta, or alternatively support Save Our St. Green Valley before the Supreme Court. And so I think that those, Mr. Hoyt, might be questions that we can defer to another day after we see whether cert's granted and what the is going to happen with the case. But it's something that I think all the board members should think about. Have I gotten that right, Mr. Hoyt?
Yeah, we can cross that bridge when we get to it.
Okay, wonderful. Is there anything else that Mr. Hoyt or any of the staff members would like to address before we close for today? All right, hearing no other requests, today's meeting of the Board of Adjustment is hereby closed and concluded. Thank you all for your time and attention. Appreciate it.
Thank you.